Mhm.
Hey, Yvonne, how are you?
Good, David. How are you?
Good. Trying to get some work done from home. It's not as easy as one would think. I feel like it's April again.
I've been in my office the whole time. At home I would get too distracted. I would be playing with the dogs all the time.
Well, I have two cats and they're my office mates. One's usually with me and one's with Margie up in her office. But I could usually focus. It's just yeah, sometimes you don't have the right files. You don't have the information you need. You have to wait till you go back to the office to finish stuff. It's better than nothing, but it's not great.
I'll tell you though, one thing I have to say is this whole pandemic thing has certainly improved my technical skills, which are still pretty frightening, but nonetheless.
That makes two of us. You see, we're the same vintage. That's why.
Sad but true.
These newly minted lawyers know all this technical stuff and they just go like this with their fingers and it's done. And
I know.
we're over here trying
I
to
know.
figure out which button to push.
Absolutely. They came cable ready,
Yeah, I did not.
I did not either.
We still get our work done. Experience counts for something.
Thank God it counts for something. Because if I had to exist on my technical skills, I'd starve to death.
Yeah, and I'm lucky I have my paralegal because a lot of times I just call her and tell her what to do and she does it from the office and it's done and I'm home and it's taken care of. So
Yeah, we have some young people in the office. In fact, yesterday I had to get them to help me with my cell phone. And thank God they know what they're doing.
yeah. By the way, our social worker is very nice, very friendly, very helpful. Thank you for referring her to me on that case.
Oh, good.
She called me yesterday. We talked, so it was good.
Excellent. Thanks. I'm glad to hear that. She was like with CPS or something before, child services or something. And I think she's going to be really good.
Well, she understood the issues as soon as I started explaining them. And then she said the same thing I said. Well, this kid is almost 18. Why are we making mom do a parenting class? Maybe we could get him to waive it. And I'm thinking maybe, if she explores, there are no parenting classes or nothing that's really applicable, maybe a letter from her to DSS saying, could we waive it, might help us. I figure it can't hurt.
No, can't hurt. That's great. I'm glad to hear it.
Yeah, I appreciate you letting me work with her on that case because I think it's going to help finish the case quicker.
Excellent. That's wonderful. I'm glad to hear it.
Well, I better be quiet because everybody else is signing in. I'll mute myself so I don't have bad feedback or something here.
No, no, I'm gonna go out and take the plea. I just have to have the Zoom working.
Oh, Lord. Um,
There I am.
Mr. Rossi, I see you up in the corner. I don't know if you see me here yet or not.
Yes, yes. Am I? Yeah, it looks like I'm not muted. Okay. Hang on. We're all here. Looks like we're a couple minutes early.
I think it's very impressive that I'm a couple minutes early because I didn't expect me to do that.
Not today, Judge. This is Lana.
I am having a little trouble. I don't see myself on the screen.
We do. So don't do anything foolish.
Okay. I'm not at all uncomfortable with that.
Judge Lavallo never does anything foolish. Come on.
Never. I paid Lana to say that.
Right.
I'm really impressed with Mr. Harrington's photo. That devil, like, you know, that like, hey, look at me hanging out here photo.
Well, that's just Jeff, you know, rakish.
Yeah. That's the word I was
Carefree.
looking for, rakish.
That's actually live. I just can't stop smiling.
Yeah. Vaughn, do we have any idea how many people were voting for? I mean, how many people had registered? I forgot to ask Diane.
I think we had, I think we had between 35 and 40, so we're getting close to where we
Okay.
should be.
It is now exactly 12:15. We'll give them 2 minutes.
Okay.
This is everyone's 2-minute warning.
Honestly, but that's the maximum. And 5 years post release supervision.
Right, so from our standpoint, Judge, yes, obviously there's some moving parts here, and I'm not going to assume that the court would commit to a minimum. I think that is more than fair, more than reasonable, given the circumstances. But obviously, if we can't get a number that we believe to be fair, then we would look to vindicate Mr. Goldson's right at trial. We're just looking for something fair here, Judge. It's as simple as that.
All right, but you're telling me
I
that.
think
He needs to
mute
mute.
Michael. If Michael, is it Tomasi? You can mute him.
So long as the court would consider giving it less than 8 years.
Mike Tomasi, you need to mute yourself because we're listening to your court appearance.
Nope, we're done.
How did you know who it was?
On my screen, I can see
Yellow.
speaking by a little, like where the audio is, the scale goes up.
Right.
Oh,
Or if you're looking at video, sometimes you'll see a yellow outline around.
Right. Oh, yes, you do. Okay. I see the little yellow outline. I didn't see the video thing go up and down, and I couldn't find. You have to be on the right half of the presentation.
No, Judge, if you click on participants on the bottom,
Yep.
then you will see
Oh,
the
then you do see
microphones
that.
and video cameras. So whomever speaks had like a little scale going up and down.
Okay.
All right. It looks like we've got 40 people here. It's now a bit after 12:15. It sounds like time to start.
Okay.
Is everyone ready?
Ready when you are.
Thank you. We are very happy and fortunate today to have this presentation on evidence in the family court. Our presenter is someone I believe most of you, if not all of you, should know, Judge Sharon Lavallo. Judge Lavallo has been on the bench in the family court for about a dozen years now, from having first been appointed and then ultimately being elected to the bench. Before that, she was a city court judge, and before that, in the district attorney's office. Obviously, she is one of the more knowledgeable folks we could have
Oh,
on the topic of, and so I will wonder why my computer is doing something funny. Have I lost everyone?
Yeah, it happened to me too.
yeah. Everybody's computer's doing something funny.
We're viewing Wallace Weems' screen in the top.
Somebody is sharing their screen without noticing it.
That would be Wallace.
It's Wallace. Okay.
Wallace, you need to unshare your screen.
All right. I love,
I can still hear you, Frank, though.
yeah, I mean, I
Yeah,
can
well,
just
that's
start,
not always a good thing, is it?
yeah. How about I just start talking and we work on,
Yeah, Wallace will keep working on it. Otherwise, who's hosting this? We may have to shut her down and have her come back in. Anyway, I am now going to turn the presentation over to Judge Lavallo. Take it away.
okay. So let me start by saying there's nothing worse than having somebody introduce you and say, she's one of the most knowledgeable, because I'm bound to say something that you all disagree with. And that's fine. If you have questions or, you know, take issue with something I said, feel free to put it in the chat box. And I'm sure that Frank or Yvonne will, or whoever's in charge of that will let me know. I think an evidence CLE is really important, because I think, like a lot of things, we get very lazy with it. And we do things quick and easy, and we forget what we need to do. And I would tell you that in the age of COVID and in the age of remote or virtual trials, I think that these evidence issues are becoming more and more important, and our kind of relaxed attitude toward them is not going to fly as well. So I think when you're talking about evidence, it's always best to start with the most basic concept. And the most basic concept is, what is evidence? Evidence is either testimony, a photograph, a document that is both material and relevant to the issue at hand. And I'll give you the Black's Law Dictionary. You have in front of you the Black's Law Dictionary definition of material. It's pertinency to the issue in dispute. It's something that has an effective influence on the trier of fact because of its logical connection to the issue. Okay, so the example we gave is really what's not material. In an educational neglect case, the fact that the respondent was hostile to a caseworker is not material, because it doesn't prove anything that has anything to do with the trial issue or the issue at fact or the whatever. The issue at the factual issue that the trial is about. Relevant means that it's evidence that tends to make a fact more or less probable than it would be without the evidence. And that fact is of consequence in determining the action. The evidence makes a material fact more or less likely to be true. So in an abuse case based on domestic violence, the fact that the parents often swear is material, because it talks about their tone and their temperament, and it touches on the subject matter. But it's not necessarily relevant to the question of whether or not on a specific occasion there was domestic violence in the presence of the children. My request that everybody pay attention to the basic definition of what is evidence, and that it has to be material and relevant, is going to be followed by my saying, do I think a lot of judges make a distinction between material and relevant and rule on that exactly correctly every time? No. And I think it's a very blurry line, but it's something to bear in mind. Number one, when you're preparing your evidence for trial, and number two, when you're making your objections. The better you make your argument, the more likely a judge is to rule in your favor. Before I go into talking about rules of evidence in particular, what I wanted to address is one of my big issues with evidence is how evidence should be marked and handled before the court. And I'm gonna do it mostly in the age of COVID, in the age of virtual trials, because that's what we're dealing with. But the general principles that I'm talking about here apply throughout. This says at least 2 days before trial. I want to emphasize the at least point. At least 2 days before trial, a witness list and an exhibit list should be submitted to the court and to the other parties. The petitioner, the moving party, is petitioner 1, 2, 3, 4, 5. Respondent is A, B, C, D. AFC, ask your judge if it should be AFC 1, AFC A, how it should be done. But one party has to be 1, 2, 3, 4, the other party has to be A, B, C, D, or you're already starting with a confusion. The moving party uses numbers, the responding party uses letters. The way I've asked people to do it is in addition to submitting the witness list, they submit each item of evidence to the court in a separate PDF file. If you don't know what a PDF file is, ask Tom or someone who's really good with computers, not me, but every item should be submitted in a separate PDF folder. For trial in my part, all of that is going to be put into one folder for your trial that will be kept so that if there is an appeal, everything that was marked into evidence is together and can be sent on. The cover of the first page of each exhibit that's submitted to the court should be a cover sheet. The cover sheet should be labeled Petitioner's Exhibit 1, if that's what it is. A description of the item. So menu, contract and plan for services, dated, whatever the date is, and approximately how many pages the exhibit is. The reason I'm asking you to do that is because, number one, I can see what the exhibit is without reading it, if it's something that you don't necessarily want me to read, because it's going to be my job to display it to the parties. Number two, it just gives everybody, as well as the appellate division, a clear idea of what that exhibit is. So if we've marked it incorrectly, it's easy enough to recognize that and correct it. Okay, let me make sure I'm sticking to this and doing it in order so I'm not confusing you. Once we begin the trial, if you ask me to show an exhibit, if you need an exhibit shown to a witness, I will share the screen. I will make sure that I initial the cover page. So this is for identification, petitioners 1, SML and the date. I'll do that to the cover sheet and the first page of the exhibit. And if it's moved into evidence, I'll go in and do the exact same thing. I will be able to edit the PDF file. So I'm marking the exhibit itself as being moved into evidence. And again, all that's with the hope of making sure that we have a clear record should the matter go up on appeal. Is that mostly clear to everybody? Okay. The other thing I would point out is I've asked you to send this all to the trial all to the court, in electronic form. When you are talking about things like medical records and you are talking about things like connections notes, it is incredibly helpful, if not almost a necessity, that those exhibits be paginated. I don't know if that's a real word, but it's become one in COVID. You have to have a page number. Otherwise, there's no way you can ever refer a witness or the court to any particular part of the document. It becomes virtually impossible. If there is something specific within a document that's that size that you know for a fact you're going to have to refer to, ask to have it marked as, petitioners 1A so that if a witness has to go, we can refer them to that page specifically. And again, it protects your record on appeal and it keeps the procedure moving. I'm spending a lot of time talking about this, so I'm going to try and move on. But I'm just trying to give you the idea of how we're handling this. I do want to point out that photographs, if at all possible, should be put in a PDF format so that they can be marked into evidence as well. I would ask that it's very helpful when we're doing this, if ahead of time the parties meet and decide if there's any documents that you're going to stipulate into evidence. Again, this is cumbersome, it's time consuming. If it's a document that you know is going to come in or that the foundation is easily laid, you might want to consider stipulating it to save time. And there was one more thing I wanted to make sure I included. All right, I guess if I forgot it, somebody will remind me.
Do you mind
Next.
a quick question, Judge?
I could take a quick question.
You were talking about screen sharing for exhibits and such. Would you have an objection if some small exhibits perhaps? Our folks, many of our clients will be looking at these things on their little smartphone. And if they've got eyes as bad as mine, things will be impossible to see. Are you okay with having them obtain, we would send them paper copies of something I know I'm going to ask them about? Is there a problem with having them look at a document if as long as I say it's a copy that I sent, which is exactly the exhibit that was sent to the court?
I don't have a problem with that. I think it makes sense. Generally, what I've done when that's come up is I set, the person as an officer of the court represents that it is a copy that they have sent. It is the exact copy that's marked into evidence. And I ask if anyone has an objection. Depending on the circumstances, I might overrule that objection. It just seems to me to make, again, I know I was talking to one judge who told me she wouldn't allow a photograph in because it wasn't best evidence, because it wasn't the original photograph. I don't think the appellate division is ever going to say that letting in a photograph or a copy of a photograph under these circumstances is a problem. I think they're going to expect us to make some accommodation for people appearing remotely. And I think that if you're going forward with a trial and you have a respondent who is limited to what they can see on their phone, a court would expect out of fairness that they be given something they could actually read.
This brings up another issue just touched on briefly by, I think, Jen McCann. There might be documents. Let's say my client keeps a diary and I'm going to have her use that to refresh her recollection about the various dates they have things. Unfortunately, if you're the one sharing the screen, you're going to see where not only does she recite that she talked to the other person on November 19th, but you're also going to see where she wrote, talk to that so-and-so, 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 and, he can this, that, and the other, and a whole bunch of stuff that under normal circumstances, we would never in a million years want anyone to see. But she kept all of this along with her important information within her diary. And I think there was a question of, oh my God, the judge is going to be seeing an awful lot of documentary evidence through screen sharing of documents that are not actually in evidence and might never get into evidence.
Which, again, one of the reasons I said that you have the cover sheet is to limit what I absolutely have to see in terms of flipping through exhibits and displaying them to people. The second thing I would say is I think this calls upon you to really be more prepared for trials. So if you know in preparing your client for testimony that you might need to refresh their recollection, number one, you want to have that exhibit marked ahead of time, because even if you're only refreshing their recollection, it has to be marked. So pull out the pages you think you might need and mark them. If it's not going into evidence and it's only being used to refresh their recollection, you can cover up parts of it. And I would remind you that even though you didn't necessarily show it to the judge when you were refreshing recollection, you were obligated to show it to opposing counsel. So, you know, I'm pretty clear on the fact that sometimes when people fight, they call their spouses names. I might have even done it in the past. So I don't think that's as detrimental to your client as you think it is. I just think it's helpful. You know, if you think there's something you're going to need to use to refresh someone's recollection, don't show the whole diary. Don't mark the whole diary. Mark a few pages. The other thing along those lines I would ask is please, please, please have enough foresight to mark petitions, menus, statements, anything like that that you think you might need to use to refresh recollection. It is incredibly tedious to do it while the trial is going on. I can't begin to express to you how tedious it is to do while the trial is going on. We can do it. If it has to happen, it can be done, but it takes time. And, you know, we judges have various degrees of technical ability. So do what you can to get it marked ahead of time. If it's okay. Oh, last thing, when you mark exhibits, every photograph is its own exhibit. Every record is its own exhibit. Obviously not every page of the medical chart is its own exhibit. But remember, the purpose of marking an exhibit is so that the appellate division knows what you're referring to. So when you mark your exhibits, mark them in a way that if someone says, I'm showing you exhibit, you know, petitioner's exhibit 1, they know what you're looking at. If you have 4 photographs on one sheet of paper, they don't know what you're looking at. So just bear that in mind as you're marking exhibits. All right, so the next thing I wanted to talk about is motions in limine. Motions in limine are not, actual motions that require you to, you know, follow the exact format. It's not a formal motion. So you could just submit an affidavit to the court explaining what your position is and why you think a certain piece of evidence should be excluded or why a certain piece of
I think
evidence
it's going to be before that
should be allowed.
because
What?
of his papers. So I will, I'll keep you
Oh.
posted.
Okay.
Okay.
And I would say that, you know.
Oh my God, you can go right away.
Can you make a motion and limine the morning of trial? Sure. It's just not the best time. You know, just like you have.
You are only to me. You're
Judges
not
have-
sending anything to anybody but me.
So just like you have to research issues, sometimes I have to research issues. And the more time you give
Okay.
me to do that, the
All right,
better.
man, you have a good weekend. And as I hear something, I'll let you know. All right.
All right.
Good luck with your 2.
So again, I would ask that you submit those as early as possible. The earlier, the better. And just some ideas of some things that you might want to consider a motion in limine about. So let's say you look at the witness list and it's, you know, there's, you know, several experts. There's some people that, you know, are just, you know, crazy neighbors or friends of the respondent who weren't present when whatever is at issue is happening. Say to the court, I'm asking for an offer of proof relative to these witnesses. I think they lack personal knowledge of what's happening or what happened on the day in question. I believe their testimony is going to be cumulative. So you ask for the offer of proof and the attorney can either establish something that's, the attorney can either establish that the witness is not simply cumulative or that they do in fact have personal knowledge, and we can go from there. If there's an expert that's being called that you don't believe can be qualified, then by all means, make that application ahead of time. So for example, let's say your client says, I have an expert in the field of healing by rocks, and I want you to call them. And so you are, despite your best efforts, you are on your witness list putting Dr. Bob Smith, healer by rock. The other attorney can say, I don't believe that's an expert who's relevant in these proceedings, and ask for an offer of proof and ask for some credentials. And perhaps at that point, you save a long time of trial because you've been able to rule it out in the beginning. Or you can establish that this is a person whose expertise is not relevant to the proceedings. Okay, so he's an expert in, childhood obesity, and this is a case about drug addiction. His expertise is not relevant, and so he can be excluded. You can make the same kind of motions for documents. You can object that there's no proper foundation, no proper certification, that they're not relevant. You can make a motion in limine to have documents redacted, so only those relevant portions of the documents come into evidence. You can make an objection and ask to have the hearsay in a document redacted. And again, all of those things, if they're done ahead of time, you're more likely to get a ruling in your favor. If you make an application the morning of trial or during the middle of somebody's testimony, it's more likely a judge is going to say, I can figure that out. It's just coming in before the court. I know what to exclude. If you make the motion ahead of time, when there's actual time for people to argue it and take action, they're more inclined to rule in your favor. And so again, being prepared and doing some of that ahead of time is well worth it. So is there anything else about motions in limine? Was that quick and clear enough? Yes? Okay.
Judge, it's Lana.
I keep looking at either Frank or Yvonne to nod and tell me just keep moving.
I think Yvonne had, I think Lana had a question though.
Oh, I'm sorry.
Judge, thank you. I think there are a lot of practitioners who are not familiar what the limits of motion in limine is, what's appropriate or not. Sometimes practitioners, and I'm speaking from my own experience, if we didn't do something in the proper time and now it's eve of a trial, we put everything in motion in limine, but I would like you to talk about a little bit, just briefly, what would be an appropriate and inappropriate request for motion in limine.
So my general rule of thumb is that a motion in limine would really be referring to an evidentiary issue. It would have to do with witnesses. It would have to do with a specific piece of evidence. A motion to compel or a motion to preclude is not a motion in limine. And there's very specific procedures that you need to follow in those circumstances. And again, this is a great example of something that in family court, we've always been kind of lax about. Oh, I'll get you the discovery. I'll get you the discovery. And then the morning of trial, oh my God, you never gave me the discovery. As a court, there's not a lot you can do at that point. So an issue like that has to be, first, there has to be a motion to compel production. Once you have the motion to compel production of evidence, if it's not produced at that point, then you ask for preclusion or some other remedy. And that is appropriately done by formal motion in advance, I would say well in advance of trial. If trial's Monday, don't bring that motion on Friday. That's not timely, and it doesn't do anything to allow me to fix the situation before I lose a week of trial time. So I think Lana's point is well taken. Is there any other questions about that? Okay. So Next, we're moving on to the foundation for physical or for documents. And I would point out, once you have a document marked, again, you're always doing the same thing with a piece of evidence, regardless of what it is. You are identifying it, you are establishing it's relevant to these proceedings, and you are establishing that there's something reliable about this document, that there's some reason that we should look at this document and believe it is what it represents to be. So the first question is always, you hand them, I'm showing you what's been marked Petitioner's Exhibit 1 for identification. Can you identify this document? Yes. What is it? It is a letter I received from DSS telling me that I was the subject of an investigation. The next question, how do you know that? How do you know what it is? I got it in the, I got it in the mail. It's got my name on it. I took it to the CPS attorney and we talked about the letter and she told me, yes, that's the letter I mailed you. But that's what you're doing with a document when it's given to you. There are specific types of documentary evidence that get moved into evidence all the time in family court. One of the things we talk about regularly are business records. They come in pursuant to CPLR 4518A. And actually, yes, business records are hearsay, and you're laying a foundation for business records to come in. But what you're really doing is you are establishing the hearsay objection. You are identifying the document and you are telling us why we should rely on this document. So you show someone, I'm showing you what's been marked Petitioner's Exhibit 2 for identification. Do you know what this is? Yes, it is the record of attendance at Catholic Charities supervised visitation. And how do you know what that is? Well, I know what that is because I work at Catholic Charities supervised visitation, and I am the one who, sits at the desk where this sheet sits. Okay. And is that made in the regular course of your business? So do you, as part of your job, make this form? Yes. I'm required when people come in to every day, jot down who walks in the building and what time they walk in the building. And is it part of the regular course of your business to retain this record? Yes. The end of every day, we take it and we file it, in the book of the guest log, and we keep it. And that is kept as part of our business every day. And then you say, the information that's kept in this document, is it recorded close in time to the event that occurs? Yes, I recorded just as people are walking in the door. It happens simultaneously. You've effectively laid the foundation for that document to come into evidence. There's going to be objections. Did you yourself write this line of text? Do you know that all of those things are counsel's jobs to raise the objection? Just because the objection is raised doesn't change what the foundation is required to allow the document to come in. And I think a lot of those objections go to the weight that should be given a document. There are a lot of those questions or objections are things that would go to telling the court why a specific piece of evidence shouldn't be given much consideration. Obviously, the example I gave you isn't a great, doesn't allow for a lot of argument per se, but that is the general foundation for a business record. It's different when you're talking about a certified record. So when a business record is moved into evidence, you need someone from the business there to lay the foundation. When you're talking about a certified document, that foundation, that element of credibility is done on the certification form itself. And there's specific rules in CPLR 3122A that lay out what the certification documents need to say. One of my personal pet peeves is when someone says, "Hi, can you look at page 1 of this document?" Yes, what is it? It's a certification page. Can you read me the certification page? That's not how you lay the foundation. That does nothing to tell me, the trier of fact, how that document is relevant to these proceedings or that it's at all related to these proceedings. What you should be doing is saying, I'm showing you what's been marked. And again, this doesn't have to be done by an employee of the business because that's why it's certified. So for example, you could say to someone, did you get the hospital records? Yes, I did. And did you request those in a certified form? Yes, I'm showing you what's been marked People's Exhibit 1 or Petitioner's Exhibit 1 for identification. What are these? These are hospital records. From what hospital? Oishei Children's Hospital. Who was treated on that date? Well, Bobby Smith was treated on that date. And, or what date was he admitted? He was admitted July 1st of 2020. So Bobby Smith was admitted to Oishei Children's Hospital on 2020 or on July 1st of 2020. And this is a trial about Bobby Smith getting injured on June 30th of 2020. We have now shown how that document is relevant. If someone wants to stand up and say, I object, those documents are not, those certified documents are not properly certified, then we discuss the certification page. And we do that by me looking at it. I look at you tell me what you think is wrong with it. I look at it and decide if I think the certification is appropriate. And if it is, we move it into our evidence. What people tend to do is they say, we go through this whole thing of the certification, and no one's ever told me who the medical records belong to or why these specific medical records are relevant to these proceedings. Maybe they're records from the day that Bobby Smith was born 5 years ago. They're not relevant to this proceeding about his injury. So establish the relevance to this specific trial, who, you know, and go from there. All the same foundational elements are going to be included, that these are records that are made and kept in the regular course of business, that they are kept in a contemporaneous nature as they are recorded, and that this person has a duty or an obligation to make these records and retain them. So again, we go to hospital records next, which are admissible. Certified records are admissible through CPL 4518C and CPLR 2306. Which says that the certification is prima facie evidence of its authenticity. What I would point out is that if there are specific portions of medical records that you're going to need to refer to, so oftentimes medical records come in and they are 2 inches thick, and really what you want to focus on during you know, your examination of this witness happens to be the discharge order or you know, an x-ray that was taken on day 3 or a bone scan. Mark that as a separate exhibit so that you can refer to it easily in your questioning, and the appellate division can refer to it easily during questioning. And I would point out that, yeah, let me leave it there. I do recognize that when we talk about entering business records and hospital records, they are coming in as an exception to the hearsay rule, and that sometimes these documents contain double hearsay. Should I even talk about triple hearsay? And it's frustrating, I think, to respondents because judges are always like, yeah, we can separate that out, movement evidence. What I would say is, if there is something that is incredibly damning to your client in those records that is double or triple hearsay, and you don't believe that there's an exception for it, then I would make a motion to redact that portion of the records. I think that makes sense. I think that protects your client much better than simply say, oh, I object, those contain hearsay. Because you haven't really pointed out that, you know, a specific section of the records that are problematic or that should have been kept out. And again, that's something that should be done as part of a motion in limine. It should be done a few days, few weeks in advance. And you're more likely to get a ruling in your favor if everybody's had time to look at it and actually address what you're asking for. You might be surprised, and the petitioner might even say, yeah, I'll agree to redact pages 22 through 47 of the medical records because they're not relevant or because they're double hearsay or whatever. I think a lot of these issues could be addressed by simply talking to opposing counsel. And I'm really not saying this because I'm lazy and I don't want to do my job and make rulings on the evidence. I'm saying this because as you go through a trial, every one of these things that comes up during a trial brings everything to a crushing stop. Everybody's got to stop and start looking at things. That's bad enough when we were all in the courtroom and we had the document right in front of us. It is damn near impossible now to do electronically. It is painful to do electronically. I've done about 10 virtual trials. I promise you. You need to do as much ahead of time as possible.
Quick question, well,
Sure.
question, sort of comment, Judge. I think
Right.
most of us have gotten better at it, but it was always a frustration, and I'm sure you'll want to point out to everybody that if they're subpoenaing records for a trial, for heaven's sake, don't subpoena them to arrive on the morning of the trial. Subpoena them to please arrive well in as far in advance of the trial as you can so that everyone does have a chance to look at them. My other question is, let's say the hospital records, which my reading of cases and the law basically say the statements that are made for the purposes of diagnosing and treating a person, they come in because you expect that whoever's talking about that is being truthful about where they hurt and such. But if you're saying redact and we don't get cooperation from counsel, how do we get around a situation then perhaps those very things that we don't want in there? Oh, and while he was there, he was arguing terribly with his girlfriend. How do
So,
we get those redacted if you're going to have to be the one who goes through and decides what to redact or not redact?
well, that's not a bad question. I think that's what I have Tom for. I think some of those things Tom can go through and look at. I also think I guess I'll talk about this a little bit now. Some of those things might have other hearsay objections that apply. So it might be a statement against a party interest. It might be an excited utterance. It might be some other things. So there is going to have to be a ruling on that. And just like any other time, I make a ruling to, exclude something. I've seen it or gotten some wind of it. But I think you've made your record. It's clear. And I think if you can get the judge to say that's not admissible or that should be redacted, I think it goes towards your argument that can't be considered in rendering a decision in the case. I mean, I think it's still to your benefit. I get that in family court, especially, and with bench trials and with everything being virtual, you do in fact see a lot of these things. But I think it just makes your argument stronger as you go. If I don't know that came out right, but you're right. Yes, some of these things I have to see even if I'm going to redact them, but I'm not reading them in detail. I'm skimming them. And if Tom does the redacting, unless there's some issue where people take issue with what he's crossing out, it'll be done before I see the records. And you do have to be prepared if there's another, as I said, if there's a second hearsay objection that would apply to that statement.
Judge, at this time, then I'm going to take a minute to give the first code for this session. So I hope everybody's listening, otherwise you're missing it. The code is 4518. 4518. Anyone who's been paying attention knows where that code came from. It was 4518.
Judge, could I ask a question?
Sure.
Regarding hospital records and self-authentication, hospital records with the appropriate certification are self-authenticating. You don't need a body. But records from a pediatrician's office, records from Horizons that contain the certification, they are not self-authenticating. Is that correct or wrong?
I think if Tom or someone wants to chime in with me, I think that records from the pediatrician are medical records, so it would be self-authenticating. I don't know, I'm waiting for someone to jump in and tell me I'm wrong or I'm right. I think Horizons, it depends on what kind of records you're talking about.
I guess I'm going to ask a question then. I don't understand the purpose of 3122A and the certification if you have to get a body in there. What's the, right?
Yeah, I don't think you need to. I don't understand. I would allow them in. But then again, I'm generally more inclined to allow something into evidence than keep it out. I don't know if anybody else wants to chime in.
Could I ask one other question, Your Honor, regarding evidence? The only one I can think of is arrest records or police records. When they're certified, you need the consent, the commissioner, for example, or somebody in authority gave that person permission to certify them. Will they come in? That's the only record I can think of, but there could be others. Will the record come in without that consent, attached to the certification?
It's not supposed to.
Okay, thank you, Your Honor.
And we'll get into, I guess police records are one of the things I wanted to talk about. It's the same thing as with medical records. You don't necessarily have to have a police officer there to lay the foundation for those records if they're certified. By the same token, if you have an officer there to lay the foundation for those records, they don't need to be certified, right? And the officer who lays the foundation doesn't have to be necessarily the officer who created the records, as long as he can talk about these are records that are created in the regular course of business. It's the regular course of business of the Buffalo Police Department or the West Seneca Police Department to retain these records. And you would lay that same foundation for the documents to come in. Now, of course, can you say, well, you didn't make this record, so you don't know if this particular, you can attack it on cross-examination. You can attack the weight that the court should give the record, but it doesn't stop it from being admissible. The other thing I would point out, the big thing with police records, and I'm jumping around, I think a little bit, but not much. There are portions of the police records that are going to come in, who the complainant was, the address of the call, the nature of the call, what, the time of the call, what time they arrived on the scene. And the police officer's observations, but certainly, again, it's another case where through a motion in limine, you can ask to have the narrative portion of the document redacted. That isn't the officer's observation, that's just the recording of the statement that they took from the witnesses. I think that's really all I want to say about that, unless there's a specific question. The other big issue that we have with records in family court are connections notes. So I would say that generally speaking, the same rules apply as to hospital records and police records. The big difference is that connections notes often contain multiple levels of hearsay. And I would suggest that if there's a specific section of connections notes that someone wants to move into evidence for whatever reason, that specific section be marked and as a separate exhibit and a foundation laid relative to that. I generally speaking, think clearing up all of the double and triple hearsay is near impossible. In my opinion on that, I have to be honest, changed. There was a time when I would allow connections notes to come in pretty regularly. I don't do that anymore. But again, there would be occasions where I would allow sections to be admitted. I would point out that connections notes are one thing that in order to refresh the recollection of a caseworker, I have allowed them to look at the connections notes, a hard copy of connections notes in front of them, as opposed to the ones that have been marked for identification, just because it's easier and it makes more sense. I know somebody had asked about that earlier, I think Mr. Rossi, about using a hard copy or a physical copy for a witness to use. I think that's a situation where it makes sense. So moving on, I'm trying to go at a good pace and I think we're okay. The next thing, photographs. There is a foundation that you have to lay for a photograph. Again, my preference is always going to be to have one photograph marked per letter. So I'm showing you what's been marked, petitioners 1 for identification. And again, you have to lay the foundation. So what is this? This is a photograph of my house. Okay, what's depicted in the photograph? My house. It's the witness isn't saying my blue house marked 423, Main Street. They're just saying my house. Is it an accurate reproduction of the condition your house was in at the time the picture was taken? Yes or no? That's the foundation. Is it a fair and accurate representation of what's shown in that picture? So what am I showing you? I'm showing you a picture of Bobby Smith with a broken arm. When did Bobby Smith have a broken arm? On March 3rd. Is this a fair and accurate depiction of what Bobby Smith looked like on March 3rd when he had a broken arm? Yes, it is. Okay. You don't have to have the person there who took the photograph. You don't have to, whatever else is always raised is that, we can't allow this into evidence. Do you know what kind of camera took the picture? Do you know if it's, how many, whatever technical question you might ask? None of that is relevant. It's just, is this an accurate reproduction or an accurate depiction of what's shown in the picture? And the next thing is electronic testimony or electronic devices, text, social media, email, Facebook, all of it.
Judge, could you bear another question?
Sure.
Well, it's about the super certification. I'm talking about Family Court Act, Section 1046. So this is confined to Article 10s. But of course, down in there, it has a subdivision A4, and it requires that not only there be a certification with the records that you're submitting, but if the certifications by the head or reasonable employee, et cetera, it has to also have an additional statement that of what that person's authority is and that they have the authority to sign that certification. That's not the usual certification you find on medical records and hospital records. And when it lacks that, supposedly it then falls short of the requirements of Section 1046A4. So how do you deal with that?
Okay, so I'm thinking back, and I'm not thinking that I see that the certifications that are coming in are lacking that. Generally speaking, I think those forms are being filled out. Am I off base on that?
Well, has anybody faced that objection as I have in an Article 10 proceeding, and the position of the department is, oh, well, you don't have the magic words in the certification.
Post it on Facebook.
No, I think he's going back to medical records, but I guess if the proper certification isn't there, they shouldn't be admitted. I'm just saying to you, I don't think that I found that it hasn't been included. And I'm asking, are you talking about records that you seek to admit?
Supposedly either side. Whether it's medical records or any records, let's say of police, any business records, for example, that normally would be admitted, say with certification of an agency, let's say police records or something like that. They have to be certified properly under Article 10, and this only applies for Article 10 cases. It has to have that extra additional wording of how the person has the authority to be able to sign and certify the records.
I guess what I would say, Mr. Kitchen, is it does have to have some, you're talking about the designation of authority to keep the record and to authenticate the record.
Right.
And if you asked me to quote the statute, I wouldn't be able to. I could read it to you and still not be able to quote it 2 minutes later. As long as what is written, I think reasonably confers upon this person or establishes to the court why this person would be the one authenticating the records, I would take them into evidence. But I do think there has to be some designation of authority included. How strict any specific judge would be and what that wording has to be, I can't speak to. I don't know if that answers your question. I mean, it should be there. And if it's not, certainly make the objection and reserve that for the appellate attorney to address.
Judge,
yes.
this is Lana again, jumping in. Sorry, guys. We
Okay.
had that multiple times, that very issue that Dennis is presenting. I recall the specific case that was in front of Judge Rodwin with a pediatrician who certified a record, and we were not sure if the certification by someone other than the head of the hospital or agency was not accompanied by a photocopy of a delegation of authority. What we did, we caught that prior to trial, and department caught it. That was not proper. So what had happened, they brought a proper person then to testify not about what was in the records, but just the certification. But I think since then, and it was maybe 2 years ago, that the DSS attorneys for an Article 10 for 1046 been really good. I don't know if they got that training on that issue, but usually that is, of course, as respondents counsel, we're not saying anything if we see that mistake. We know that we're going to object. But I have had maybe 2 or 3 occurrences with the department. The department's attorney would be upfront with that and say, hey guys, that's missing. Are you going to object? So I know I have to call that witness. But I think that has been addressed, and department been either including now in their proposed certification delegation of authority or calling the witnesses to just authenticate the records. Thank you, and sorry.
No, you were very helpful. Thank you. Is that good, Mr. Kitchen?
Well, Your Honor, I think it's interesting discussion, but it doesn't resolve the issue. I do not understand why Article 10 contains 1046A4. Nobody's been able to explain that, and it seems to call for more certification than would normally be required in any other case anywhere.
Yeah, I think the rest of that, I think all that's very theoretical, so we should probably leave it to another time and place. Because it's easy enough to get me on a tangent. So, so going back to what I was talking about, which are text messages, emails, I'm only saying this a little bit to be funny. Please don't mark your client's phone. Please don't try and mark your client's phone. Please don't try and show me your client's phone, play music from your client's phone. Please don't do that. Print it out, copy it, put it on a CD, a disc, however you do that. Again, if you don't know how, talk to some 14-year-old who does. But it cannot be on its original device. Print it out, take a snapshot, and mark it. And then from there, you just have to do the same thing that you do for any other piece of evidence. You have to establish why it is relevant and why it's credible, why it is what we think it is. So, what is this? It's a screenshot of a text message that I got from my ex. Okay, well, where did you get it from? Well, it came on my phone and I took a screenshot of it and I printed it out. Okay. And how do you know it's from your ex? Well, there's a phone number up in the corner and that's the phone number that I communicate with my ex about. We always go back and forth about it. He calls me from there. I call him from there. That's how we communicate. And to me, that is an appropriate foundation. Same thing with Facebook postings. How do you know that's their Facebook page? Well, they post pictures of themselves on there. They post, they make comments from that Facebook page. I communicate with them through this Facebook page. And this was posted on their Facebook page on June 3rd. It's up to that person then to get on the stand and say, nope, my Facebook page must have been hacked because I didn't put that up there that day. And then it becomes an issue of credibility.
Judge, I'm sorry, this is Kevin Condon. You just kind of answered the question, but I was going to ask how you handle the objection that somebody raises that we don't know who actually sent the message or who made the Facebook post. But I guess you're saying that it's that's not an objection at the start. It becomes a credibility issue.
Right. And
Okay.
Again, if what you're doing in laying the foundation is saying, look, this is their Facebook page. They post on this page regularly. I communicate with that person about what's on their Facebook page. At that point, there's a foundation. If you want to attack the weight or the credibility of what's represented there, then you do that on cross-examination. I guess you can start doing it by making objections, but really it's not going to keep something out. It's going to go to, it's going to go to the weight that's given it or the credibility that the trier of fact gives it.
Thank you.
Yeah, I mean, the outline itself says, proving that it's fake isn't a part of the foundation. That's the burden of the objector. So if you're going to say it's fake, you have to be able to say why you think it's fake or offer some proof of that. What time are we supposed to end?
$2:00, Your Honor, 2:00.
2:00. Okay.
We've still got some time.
Okay. All right. So the next thing I wanted to just talk about is some Article 10, Family Court Act, Section 1046, just some of the basic things outlined in the statute. Proof of abuse or neglect of one child is admissible evidence of proof of or neglect of another child. Proof of injuries that wouldn't have happened without abuse or neglect are prima facie evidence. Proof of repeated, you don't need me to read this to you, right? You can all read for yourselves. Any issues or questions about any of that? Okay. Going on to the records exceptions again, is that something you want to go through in detail? Or is that something everybody can just read? I'm going to go that that's something you can all just read. I'm going to point out that reports to the central registry are admissible. And out-of-court statements by a child relating to abuse or neglect are admissible. This is one of those things that people who don't regularly practice in family court find outrageous, but it is true. They are only sufficient as a basis for fact-finding if they are corroborated. And that corroboration by any other evidence that tends to support its reliability. There are questions and issues regarding what constitutes corroboration. I'm not going to say that word again. So is repeatedly telling the exact same story to multiple people, is that corroboration? I don't think the case law is clear. Mr. Rossi says, no, it's not. I think if it's over a period of time, it factors in no. Generally speaking, it's not enough to just have told the same story. I think you can make an argument that there is consistency in what the child has said. But I think by corroboration, what they are talking about is medical documentation showing an injury. I think a sibling who can offer some testimony about what they observed, even if those statements are, again, coming in through a caseworker or somebody else, they tend to corroborate the statement or that the child is making about being victimized. I don't think the intent of the statute is that you have to have, DNA evidence, under the child's fingernails to say who attacked them or who perpetrated against them. That's the idea of the statute, is that there needs to be some corroboration that tends to support it. They're not requiring you to have evidence that in and of itself is enough to establish the offense. Am I saying that in a way that makes sense?
Yeah, and if I can interrupt first, sorry that I don't have a poker face.
All right, I rely on you not having a poker face. Go ahead.
That's the corroboration, obviously, that some people get confused. The statements of the child are admissible. They just don't prove the neglect unless they're corroborated. And some people at times try to object, saying it's not admissible because you don't have corroboration. And that's not actually the case. The statement's admissible. It's just not proof unless corroborated. Likewise, central registry reports, I think my position has always been, and I think people agree with me, it's proof of what the report was. It's not proof of anything that's alleged in the report. So the fact that the report is getting in and you might want to object to a million things, you don't need to. All you have to say, yeah, it gets in, Judge. We acknowledge that that's the report, not anything that's in it, but that's the actual report.
That is true.
So this is Jen McCann. So like, for example, corroboration might be a picture of a person with scratch marks on their face. You know, the child said dad did this and she hit the dad back or scratched the dad, right? Child says that. The corroboration is the scratch marks, the picture of the scratch marks across dad's face. That might be something.
Sure. I just want to tell you, I find it incredibly hard to come up with examples to illustrate the point I'm trying to make. So if you have one, by all means, throw it in. Okay. So next, I just want to talk about some objections. And I have, I think this is a little off topic, but I'm going to throw it in there anyways. When we learned how to cross-examine witnesses way back in baby DA school, we were taught that you prepare for cross-examination the same way you prepare for examination, which is you look at the witness, you look at what you expect them to offer, what you expect them to talk about during their testimony, and you then kind of anticipate what questions you need to ask. If it's cross-examination, you're looking at how you're going to, you know, challenge what they're saying. I think part of that is, you know, thinking about what witness is each going to offer, what document opposing counsel might be trying to admit through that witness, and then anticipating what objections you might make. And I think that's a good way to get ready for trial. And when you think about those objections, what are the objections you're going to make? Well, first and foremost, always it's irrelevant, right? That's not relevant to these proceedings. It doesn't make a fact more or less likely to be true. It's not material. It doesn't bear on the issue, you know, the issue on trial. You can argue that the witness lacks firsthand knowledge of the incident, that this is based on their reading of something. One of my, I think where this is a particularly pertinent objection is when a police officer takes the stand and they're like, were you on duty May 5th of 2017? Yes, I was on duty. And on that night, did you get a call to go to, you know, 123 Sesame Street? Well, yes, I did. And well, how do you know you went to 123 Sesame Street? Well, because it says here in this report that I went to 123 Sesame Street. Well, do you have any recollection of going to 123 Sesame Street? Nope, only what's written right here on this page. They don't really have personal knowledge anymore. They're just reading from a page. Now, obviously, if they went there and they found, you know, 4 dead bodies, they're probably going to have some recollection of what they saw. But if they went there and saw 2 people on a porch arguing, probably not. So I think that's where you can make an objection. It's not really that witness testifying. It's just that witness, you know, reading off a document and assuming it was accurate when it was made. And again, even if it doesn't keep the testimony out, it certainly colors it. Any questions, comments, concerns, strong feelings that you'd like to share?
Well, Judge,
yes.
Sorry, me again. Sorry.
Nope.
I have objected frequently when things like caseworkers. You have to be sure that when someone says they're refreshing their recollection, they're actually refreshing their recollection. And if they're asked when a certain thing happened, and they're reading somebody else's note of when something happened, That's not refreshing their recollection unless they were there and they know that the other person wrote it down at the same time. It's people know about a case, but they don't know it happened on July 12th, except that somebody else told them it happened on July 12th. That's not refreshing their recollection. And people try to get around that and use that as if they're not. It has to be an admissible recollection of their own. They can't remember they were told it happened on July 12th. They have to remember that they observed it happen on July 12th. Sorry.
As always, not as always, as is often the case, Mr. Frank Arachi has made a good point. Very good. Okay. So next, we can talk a little bit about witness testimony. And the big thing that I'd like to address with witness testimony is medical providers and the difference between a fact and an expert witness, which is something that I think we face all the time in family court. So obviously, if you're going to call an expert witness, you are required to give notice, and that witness has to be qualified, and there are a number of requirements prior to the day of trial. But if you're not calling that person as an expert and only calling them as a fact witness, you only need to identify them as a person on your witness list. Just because someone is a medical provider who has medical training does not mean that they are being called as an expert witness. They may be a fact witness. The difference is, and again, a fact witness can be a nurse who works in the emergency room or a doctor who works in the emergency room and who makes observations of the child for the purposes of treating the child. They can come in and say, this child came into the hospital and he had a 3rd-degree burn. Even though he is relying on his training to make that determination, that is a fact that he can testify to. What would require him to be qualified as an expert would be him offering testimony that this injury was not caused by accidental means. That's something that he would require specific expert training on. It's an admission. So he can't come in and say, we've all heard about a dunk burn. So if a child's being dunked in hot water, they bring their arms and legs up to try and avoid it. And it leaves a specific burn pattern that is indicative of child abuse. To offer that testimony, they would have to be qualified as a witness who has an expertise in recognizing injuries caused by abuse. But just to say it's a 3rd-degree burn, they do not need to be qualified as an expert. I'm not going to say that that doesn't get fuzzy in some places. It does. But that doesn't change the fact that the general concept applies. That not all opinions are expert opinions. If it is part of a diagnosis or of what would need to be done for treatment or a recommendation for treatment, it is not an expert opinion. Okay, this goes back to refreshing recollection. So anything you use to refresh recollection needs to be marked for identification. I know that it is not going to be moved into evidence, but it still needs to be marked for identification. It still needs to be shown to opposing counsel. And the way it's supposed to be done is the witness is supposed to say, I don't remember, or I don't recall, or, I think witnesses in family court say, can I please use my connections notes to refresh my recollection? But whatever the case may be, the witness first has to indicate that it's something they know, they just can't recall. You show them that.
Sorry, can I ask a question?
Sure, only if I can answer it.
How are you treating showing something that was only marked for identification to a witness in a virtual trial without the judge seeing something that isn't in evidence?
Again, I would say that's one of the reasons why we do the cover sheet. I show them the exhibit and I don't read it. I look away. I know that requires you to, I guess, have a lot of faith in me and to trust me. But, you know, I would point out that it's the only way I can think of to do it, number one. And number two, there is enough going on, I promise you, during a trial with bouncing between screens that I'm happy to take the 2 minutes somebody's using to refresh their recollection to do something else. I would also point out that if it is something, as Mr. Rossi has said, so let's say for the sake of argument, it's someone looking at connections notes. I'm hoping they have a hard copy of the connections notes in front of them, and I'm not required to flip through page by page by page to show them what is, you know, to help them find what it is they're looking for to refresh their recollection. If it is somebody's journal, I think that gets to be, you know, I think it's one of the challenges of virtual proceedings because, you know, it's one thing if you say to a caseworker or a doctor or, you know, a counselor, go ahead, read your notes, consider them, you know, the hard copy that's in front of you. I think people generally are more comfortable with that than, you know, if Aunt Tilly is refreshing her recollection, looking at something that's a hard copy that's not in front of everybody else. I don't have a great answer. I mean, that's the best we can do. What I have said to people who've had trials with me, and I'll say to everybody, if you're running a virtual hearing or a virtual trial and you come across a situation and you think it's handled really well or really poorly, tell us, share that information, because this is, you know, we are figuring this out as we go, and we're going to have to refine our skills and our techniques. And the only way we do that is by sharing information and our impression of what happens. So if anybody has a better idea, by all means, share it with me. I don't know if that's really satisfactory. It's the best I got. So someone just asked if you could observe a virtual trial. I got to think about that. You know, so my quick answer is, of course, you can observe a virtual trial because trials are still open, proceedings, and the public is allowed. You would have to make arrangements ahead of time. Maybe you could observe from, you know, one of the attorney's offices. Maybe you could contact one of the law clerks. I would say if you have a trial coming up and you want to get a general idea of how things are going, call Tom, and if we can accommodate it, we would probably let you. But obviously, we can't have people popping in and out. You know, I understand that we're all trying to learn, and I'm trying to be as fair as I can about the fact that they are open courtrooms. So if we could accommodate, we would try. But all right, so back to refreshing your recollection. Again, these documents are not in evidence, so you hand somebody silently their paperwork. You give them an opportunity to look at, you say to them, please review the document. Once you've refreshed your recollection, hand the document back to me, turn the document over, look up so I know you're done, and we could take the document away. And then the person is expected to be able to answer the question without reading from the document. If they begin to read from the document, then by all means, make the objection. Reading from a document, not in evidence. And it should be sustained. Remember, this is not impeachment of a witness. This is refreshing their recollection. Impeachment is something different. Yes, you can use anything to refresh someone's recollection, no matter what you're using to refresh their recollection. It has to be marked for identification. I think I said that already. Anything else we need to talk about relevant to that? Okay. All right, so here we go. All right, so okay. So objections, I'm just going to do this part real quick. Objections in general to relevance or materiality, that a person has no personal knowledge, that the subject of the testimony is not at issue. So if it's like character testimony, you know, he couldn't possibly have beat his child because he's a really great guy. That it's cumulative, so multiple witnesses have testified to the exact same thing. You can testify to something being beyond the scope of direct, so that they're facts that are not an issue in the case, so they don't need to be addressed. On cross-examination, when you make the objection, Mr. Rossi is going to laugh. I hate when people say it's beyond the scope of direct examination, because largely I'm a let's move things along kind of person. But there are in fact times when something is not something that is ripe for cross-examination. If it's testimony you want to elicit for the witness, you should call them as your own witness. And the reason the rule is there is because then you can't lead and all of those other great things. But I do have to say that it's not something that's going to be strictly enforced, especially when there's not a jury there and we're looking to just move things forward. Again, just because generally speaking, judges are going to ignore the rule doesn't mean it's not a valid rule or a valid objection you should make. And I do think, I told Mr. Rossi this the other day because it's an argument we've had before. I actually sustained an objection as to being beyond the scope of direct examination, because if that's something they wanted to prove, they should call the witness themselves. So even judges can be taught. I would also note that trying to limit the scope isn't a way to avoid a hard question. The question's going to come out eventually. And I would note that once you get to redirect, recross, redirect again, recross again, the further you move down that list, the more strict you should expect someone to be in enforcing that's beyond the scope of redirect, redirect. Simply getting the last word in doesn't mean you win. So at a certain point in time, just asking to ask one more question or clarify it one more time isn't really accomplishing anything other than annoying the trier of fact, because the point's been made and remade. So let it go. Move on. Leading, another favorite objection of everybody's. So leading is a question that suggests the answer. It's always allowed on cross-examination. Generally speaking, it's going to be allowed to lay foundational questions on direct. Identifying parties, qualifying an expert. Generally speaking, in that area, it's not really prejudicing anyone. And it's going to be allowed because it keeps things moving. The other thing I would say is there are times when if there's just some basic foundational information that needs to get out, You can object to leading, and maybe that's going to be sustained, but you gotta stop and think, is this really hurting my client, or is it just moving us forward and getting us through some stuff? Okay. I think that when you make objections, there are a lot of things you could object to. I don't know that every objection you can make, you should make. I think you should be tactical in what you're objecting to. If something's not hurting you and it's, you know, just tedious and the judge isn't even paying attention, why not let it go for a few minutes, right? If it's a quick answer that's going to be over and done with and it's not going to hurt your client, let it go. If someone's losing a trial miserably and the judge is letting them move a picture into evidence because really it's all they have for the day, you can object, but when the picture gets moved into evidence, it's not going to change the outcome of the case. It's just, it's been done. It's almost like a gimme, like a one less objection they can make on issue they can raise on appeal. That's not my sagest legal advice, but it is true. So there are objections to form that should be made. A lot of times when people raise the objection, they do an objection to form, and I think it's mostly because they just want to object to what's happening. If you have a specific objection to form, you can make that too. So
ready to go?
Yeah.
Okay.
question, questions. It's a fact, not an evidence. So it's based on a fact that hasn't already been established. The question is based on a fact that hasn't been established in the case. That can usually be cured by asking the foundational question. If a question is ambiguous or vague, you can certainly point that out. If you don't understand the question, chances are the witness, the judge, nobody else does either. You can make an objection that something is argumentative. And again, in cross-examination, are you allowed a little latitude in that? Yeah, you are. Can you ask a question more than once if it wasn't clear? Sure. Does asking the same question over and over again get you anywhere? Absolutely not. If they're not going to change their witness or their answer, you've made your point, move on. It is never good form to try and embarrass or shame a witness. That's different from challenging somebody's credibility. And I just wouldn't diminish yourself by stooping to just try and embarrass a witness with the questions you ask. If you're challenging their credibility, that's fine. Another objection is that calls for a narrative. So each question should ask for a specific piece of information, and there should be, generally speaking, one fact per question. That doesn't mean that every time a witness says something that's more than one sentence long, it's a narrative. That's not the case. And to keep interrupting doesn't stop the information from coming in. But generally speaking, you can't say to a witness, tell us what happened, in January of 1920 and let them talk. But by the same token, if they say, first I went to the house and then, the respondent came out and started yelling at me, that's a narrative. That's just moving the story forward. Other objections regarding form would be that it calls for speculation. As we all know, speculation is the enemy of justice. It could be a compound question, so you're asking them to give you two answers. Asked and answered, again, sometimes on cross-examination, even on direct, you're asking for clarification. Clarification is one thing, asking the question over and over again is another. The next thing I want to talk about really quickly is experts and qualifying an expert. I think there's a lot you can say about how to go about qualifying an expert. I'm just going to make a couple quick points about it. Number one, when you are asking to have an expert qualified, please ask them to be qualified in a specific field. So in other words, don't just say, I'm asking to have, Dr. Smith qualified as an expert. It's not up to the court to define what it is you are asking him to be an expert in. I might leave something out. I might not, get the exact wording that you want. I might not cover the most important part of what you think his testimony is going to be. It's up to you to challenge that. That also lays the foundation or the basis for opposing counsel to make an objection to that qualification. And it makes the record clearer. And again, obviously in the end, the court's going to rule on what it is, but at least you've put before the court what your issue is or what your position is. And I think that's necessary. If the only person who is listening to the qualification is the judge, I'm going to tell you that I don't know that there's a tactical disadvantage to stipulating to the qualifications of the expert. I understand there are some situations where you need to go through that to establish that they can testify about a specific area. Sometimes it's just time, and I think that you can make that determination. And again, I'll just point out that a treating physician is not testifying as an expert, even though part of their testimony involves them forming opinions about the patient's condition and what treatment is appropriate. And just like I said when you're preparing for your cross-examination, you want to be ready with what objections you might make to certain testimony or evidence. I think when you're preparing your case and you're going to put something into evidence, you should be ready to defend against certain objections. If you have a case or something on point for a particularly important piece of evidence, obviously have it ready, have it ready to go and be ready to answer it. And it's hugely beneficial to you and to the court.
Judge, before you get to everybody's favorite objection, you saved the best for last there. It's time for the second code, which is 1046. 1046. Once again, anybody paying attention during all of this would know why that's one of the codes. Thank you. We got about 10 minutes, Judge.
I'll do this quick then, because I want to eat lunch before my next case. So obviously everybody's favorite objection, even most of the witnesses will say, can I say this? I think it's hearsay. The definition of hearsay is it's an out-of-court statement offered to prove the truth of the matter asserted. Okay? If it's offered for another purpose, it is not hearsay. It would fall under one of the objections. So if it is to prove a person's state of mind, it's not hearsay. If it's to prove that notice was given, it's not hearsay. So in other words, an officer saying, police officer, freeze. The fact that he said police officer, freeze is not proof of the fact that he's a police officer. It's to establish that he gave notice that he's a police officer. There are common exceptions to the hearsay rule. Let me point out that the objection or the exception to the hearsay rule is not that a party said it. It is that it's an admission of a party that a statement or act which cuts against that party's position at the time of litigation. So, not everything a party says comes in as an exception to the hearsay rule. It could be a statement by a non-party that's against the interests of that party at the time they made the statement. So it's also an exception that applies to people who are not parties to the action. It can be an excited utterance. It can be a statement or a physical or a mental state, like, oh my God, I'm dizzy, or I'm so confused. It can be a statement for the purposes of medical treatment, business records. Apparently, this this must be one of Mr. Smith's pet peeves, is someone saying it's relevant doesn't make it not hearsay. And again, I'm going to throw in one of my favorites that's not included on here. I always argue that something's a verbal act. I don't, that's another one for me. I can't come up with an example now because it's been a long morning and I'm sure you're all tired of listening to me. And I thank you for giving me your time and attention, and I will answer any questions you still have, or if you're ready to go back to work on Friday or end your week, I'm happy to let you do that. Mr. Rossi, do I get to go and eat my?
It doesn't sound like we have any other questions, Judge. Thank you. Thank you.
Thank you all.
It was very good. I am going to let you, I'm going to be brief so that you can go eat your lunch, and I'll just talk to everybody else for a second to let them know of our upcoming sessions.
All right. Thank you so
Bye.
much, everyone. You have a great weekend.
I'm reminding everyone here that on December 4th is the next portion of our program, which will be direct examination. That'll be followed up in January with cross-examination. Also in December, and now for some reason I cannot find it in my calendar. Yvonne, when did we schedule that thing? The diversity one.
I thought it was like December 11th, but we'll have to double check and get that out.
I'm pretty sure and that will be a full afternoon.
Yes.
December 11th, but we'll be getting notice on that one soon.
Probably
Don't.
That notice out next week so people can save the time. That one is going to earn you 2 diversity credits, which will give you enough diversity credits for 2 sessions of signing up to be a lawyer. So in addition to hopefully providing important information, you will also glean 2 diversity credits from that particular seminar.
Don't forget to turn in your evaluations and your sheets, or else, as informational as this was, you won't get credit for it. Everybody, hope to talk to you all soon. Thank you. Bye-bye. Yvonne, I thought you were the only one called the Sign Council program. I didn't see the other one. So that's why I was sending emails privately to you, but I guess they weren't going to you. You're muted.
I thought that went really, really well. That was good.
I imagine the things will, a lot of people are listening. They can agree or disagree, but yeah, it wasn't the nuts and bolts of let's go through evidence, but I want to do that next year and dive into the code of evidence and really hit the meat of it. But I think perspectives from the bench on evidence, I think that was a good overview.
Me too. And I thought all the virtual stuff, because a lot of people haven't done that yet. I thought that was really helpful.
Yeah.
Frank, can you repeat the dates of the next CLE, the one after this?
They're coming out December the 4th is the next one. There's one, we believe, the Friday afternoon of December 11th. Now that one will be all afternoon, 2 to 5 or 2 to 4, not noon to 2. And then we got one again in January Oh God, I have a trial that day. January 15th will be cross exam. December 4th will be Lana doing direct exam. So that's always worth the price of admission. And
Okay.
then we got Brian Welsh doing cross in January.
That's the 4th is just 12:15 to 2.
Yeah, those two are lunchtime. Those two are
Right, and
lunchtime.
The 11th is all afternoon.
The 11th will be the afternoon, but we will be sending out notices. If by, if come Thanksgiving you haven't got them, contact us.
And what about January, the date again in January?
January 15.
15th?
Yeah, January 15th, the Ides.
Well,
of
15 to
January.
2. Thank you.
Today was Friday the 13th, so considering how it could have gone, this was great. Anyway.
Frank?
All right, thanks,
Who's
Frank.
calling? Somebody say something?
Yeah, Frank.
Hey, Chuck.
Yeah. Did the certificates for the first one go out yet? Because I never received it.
No.
If they didn't, yeah, okay, then let's, can we send everybody something? Can we ask Diane to send everybody something saying the certificates for the November will be forthcoming? Because otherwise,
Sure.
because I was sitting there saying, gee, I didn't get one, and
Yeah, I know she's working on them, so
Yeah,
they should be out
it's all
really
right.
soon, but I'll have her send something.
Yeah, we'll, yeah, just a little notice that says they're all
On their way.
out. Hey, has everybody, I had started this little listserv thing that with, that I basically included all of the email addresses that we had. Did all of you folks get that thing?
I got them.
Yeah, I know you got them. Dave, yeah. If
I didn't
anybody
get-
doesn't,
I didn't get one, Frank. I think Lisa Valvo forwarded hers to me, Terry McKelvey.
if you want to get on if you want me to put you on, Terry, I'll put you on it. Just send me something so I'll have your email and I'll just put you on it. So far, no one's really used it much the way I thought, but that doesn't mean they won't start. I started it because I'm on one for bankruptcy, and lawyers are always asking questions in it and I find that some of the answers are very useful, and you just see what other people are talking about. Now that's a big national thing with hundreds of lawyers. Ours isn't, but still.
Is your email address listed in the attorney book?
It is not. Are you? If it's you, I'll just send you one.
Yes, yeah, mine is listed. It's just Terry Attorney at Yahoo, Terry Addy, ATTY abbreviation, Terry Attorney at yahoo.com.
All right, and I got Mayada. Is it here? I got yours. Thank you. I can add yours to that too. Again, we haven't used it for an awful lot, but if we start, we start. If we don't, I'll probably just cancel the whole darn thing in a few months. But who knows?
I thought it was interesting when the judge talked about not looking at cell phones and scrolling through the messages. We have to let Judge Judy know that what she does is totally inappropriate.
Yeah. Let me write. You know what? As soon as this ends, I'm gonna lose these things here. Hang on. GOSMN. Gmail. Yeah. Yeah. It's a work in progress. The first trial I did with her, she wanted all of the exhibits in one PDF, and I said, I don't know that that's a good idea. And obviously, since then, no, I want everything in a separate PDF, which makes the most sense. Clearly, truthfully, we should talk. Here's what I think: if you know it's something to refresh recollection only, and is only going to be used for that purpose and not admitted into evidence, I'd add it as an exhibit for identification on my list and send it to the other attorneys. But I'd like to ask, do you really want us to send it to you? Because you're not really supposed to be looking at it. It's only an exhibit. In a real trial, that would never get handed up to the bench. That would never go in the file because it's only an exhibit for identification purposes. And then the only thing you'd have is, let's say somebody decides, you know what, I'm going to move this in. well, then they would have to forward a PDF and add it. I don't know. It's just, those are things to think about.
Mhm.
Who knows? Anyway. All right. Time to go back to work.
Okay,
Everyone
guys.
has-
Thanks, everybody.
Bye-bye.
All right, everybody. Bye.